So we've gotten lots of questions in advance. We've also got lots of great questions popping up in the chat window. So we are monitoring both of those. So please feel free. We're going to go as long as we can to get these questions answered as we move through things today. But as we jump in, David, the first thing I want to say to everybody is, not only thanks for joining us, but thanks for all the work you guys are doing. I know that this has been a particularly stressful time for everybody. And I know what school administrators are going through right now is as hard of a time and as much of a struggle as you've ever had to deal with. And I recognize that. I hear that in your voices. And, our hope is to use today just to, again, provide the guidance that we can for you all as we've had these conversations. Not everything has the perfect answer. Not everyone has a great answer, and certainly not everything has the answer you want to hear. But we appreciate everybody and what you guys are doing, and we wanted to do another one of these because we felt like the time was right as we're getting closer to that start of school and what things are going to look like. So, David,
I want to
any opening
acknowledge
thoughts?
also.
Before we jump into the questions.
Yeah, I mean, I also want to add that right now it's kind of a lose-lose situation, and it doesn't matter. I said to a superintendent this morning, it doesn't matter which decision you make, there is going to be somebody who's going to be unhappy with it. And unlike in lots of situations that we deal with, uh, there is no one squeaky wheel that you can really address. Everybody's going to be mad. There's always going to be a group that's mad. You all are doing the very best you can. And if I can free you the burden that there's a right or wrong answer as to globally, what do we do? This is one of those rare times that I'm not sure there is a profoundly, this is the right answer as to how you deliver instruction. This is the right answer as to how you don't deliver instruction in this particular environment. I think you all are doing the very best you can. And I've read a lot of plans in the last several weeks. And I'm telling you that, first of all, there's a lot of variation in the way a lot of them look, but they all come down to the same core set of principles, which is that you're trying to get education back to kids in the best manner you can. You're trying to serve kids in the best manner you can. You're trying to keep everybody safe. And I think that so long as you're doing that, if I can free you of some of the burdens here, as long as you stay focused on that goal, I really do think everyone will be okay.
Here's the lesson I've learned over the last couple of weeks, David. It's that I could think of any number of probably 100 or so superintendents that I would rather be the commissioner of baseball. And I think baseball could be working right now. If we put some of these school administrators in charge of baseball,
Thank you. Thank you.
We would all be better served.
So much agreed. I think that is completely non-controversial in this audience right now. Completely agreed.
So with that, let's jump into these questions, because that's what you're here for, is to think about that. And again, as we think through these, again, this is what we know right now. And my expectation is things are always still fluid and changing, but based on what we know right now. So I'm going to start with one that's an easy one because I know the answer to it. And that is, can we do the classroom portion of driver's education remotely if a parent chooses remote learning instead of in person? And I know I can answer that one because the ISBE's guidance document specifically says that the classroom portion can be accomplished through remote learning. So I think that is a possibility given that guidance. And so if you look in that chart on page 96, ISBE says the classroom portion of driver's ed may be completed through remote or blended learning. So first question, I have an answer to. I feel like that's a good momentum to keep us going.
All right.
So
we've got one.
we've got one. So let's move in. The next question here is starting to get us to some sports and youth sports related questions. And so with the updated guidance for youth sports from the governor, IESA and IHSA, what are the current guidelines for spectators during outside sporting events?
So I just pulled up the guidance even as we're talking, and on page 4 of the guidance, it does start into that participant and spectator uh, guidelines that continues for a couple of pages. So first of all, be aware that the limitations on 50 at a time gathering do apply even in an outdoor space separated by 30 feet. Second, be alert to the fact that the governor's office is still saying that we do have to enforce some social distancing requirements. In other words, we've got to do what we can to try to encourage social distancing. Uh, One of the questions I got last week that sort of tangents on this was, well, the visitors who come to watch the games aren't necessarily our students. They're not required to be here. They're sort of, to use the legal term, invitees. So do we still have to, could we still be liable for a transmission event among our visitors? And the answer is conceivably yes, because there are still guidelines that you are required to follow, including minimizing the contact between visitors and including enforcing those rules, including even enforcing mask requirements where people are unable to socially distance. And I think that we need to be excuse me, rational and careful with that. I do think that as a general matter, we could prohibit visitors from attending the games. I also recognize politically that may be unfeasible in some circumstances. One question I got was, could I just remove the bleachers? And if I remove the bleachers, then nobody can sit. I'm not going to tell you that that doesn't start the process, but you still need to put up the requirements. You still need to post signs requiring social distancing and encouraging people to follow those rules. And of course, if it gets out of hand, if we've got 150 people in a zone, we know that we are in deliberate indifference to the known safety risk, and we need to take measures in order to adjust what we're doing to assure that we don't have 50 people in a single space.
So the next question really gets to a lot of starting to think about some of the questions we've been getting about virtual instruction, online instruction, and how do we determine if a program that we plan to use for remote learning meets FERPA guidelines? And I think that we have to think about FERPA, also COPPA and SEPA in terms of meeting those requirements, and the Illinois School Student Records Act. Um, I would say without a multi-hour, perhaps multi-day review of the terms of service, I think there's a couple big picture bottom line answers that I think helps us feel confident in the various online platforms we might be using for delivering instruction. And the first way we can know right now whether or not a particular platform uses the Department of Education's model terms of service that are supposed to be FERPA compliant is to see if that's a platform that has signed on to the Student Privacy Pledge. And if you go to studentprivacypledge.org, you can see which platforms meet that requirement, and you'll see many of them that you frequently do are there. And just because they're not there doesn't mean it doesn't, but I think that would be an important first step. Beyond that, I think it starts to go to the settings that we're using. I mean, I would never want to use a public-facing platform or social media platform like Facebook or something like that, where there are no privacy protections. Facebook tells you they're going to mine your data and there is no privacy protection in using it, among other things. And I think the same is generally true when we talk about like a free Gmail account versus something that's part of your Google Suite, where you have different encryption and privacy features built into that. When you're using a Google Suite for education, you can have a high degree of confidence that that is not, they're not mining that for data or selling it to third parties. Now, you will see over the past few years, there have been some questions. The state of Mississippi sued Google over that issue before, but I do think that we can have a higher degree of confidence in those types of situations compared to using those free or basic versions. That's where you start to get yourself into privacy trouble.
And I've advised that as we start discussions about with our unions, excuse me, about the rules and how we're going to have synchronous transmission of materials, how we're going to have recorded transmission. This is a great time to have a conversation about what are good practices that we really want to be engaged in this year. I'm not necessarily worried when we have the regular instruction that is occurring within the classroom that is being sent home because as though the child is in the classroom, because of course, as a legal matter, you're not supposed to be developing student records within the class period. We're not supposed to be addressing one kid's student records, student grades, those kinds of things when we're addressing the whole class. On the other hand, one of the things that I think potentially gets us into a lot of trouble is one, a teacher who's unprepared for what they may see on the other end of the synchronous transmission that is occurring in the home, because of course they're not usually looking into the home. So we should have those discussions about what our expectations are. And I think another thing that's tremendously important at this time is a good reminder of we don't use our private phones for text messages. We don't use our private email accounts to discuss things with parents. This is a great time for us. I hate to talk about this like an opportunity, but I think it is one to talk about good, meaningful practices that we can engage in because I mean, every year I have a number of disciplinary sequence discussions with some school district about a teacher who is text messaging with a kid or with a parent in a way that, of course, they weren't supposed to be. And I always want to see what does the policy say, and there never is one. So this is a great time to get that into the agreement and talk about this is what a district approved mechanism for transmission is, and we're going to hold you accountable for that.
So the next question starts to get into, you know, some of these really muddy waters of the symptom checks and the self-certifications and those issues. We're going to come back to that probably several times as we go through the questions. But here is, what do you suggest for symptom checks or temperature checks? You know, if they're self-certifying, how should that look? Must they sign off each day? Are there HIPAA issues with that? And should we have teachers be doing temperature checks? We have some teachers who are pushing back and not wanting to do that. Are there concerns with teachers taking temperatures? I think that last part is the easier piece. I mean, one, the guidance says that we can have any school staff do the screening. I think the issue there is, you know, our requirement to do that would be in lieu of the self-certification. So if parents are self-certifying on behalf of their child each day, then I think that helps us be able to handle that. I do get a little, I've heard HIPAA thrown around a lot in all of this, and we have to remember that school districts, by and large, are not HIPAA covered entities. That where we are FERPA covered entities where we have to follow student records rules. HIPAA is for healthcare providers who electronically transmit certain protected health information, and generally speaking, those aren't school districts because we are generally not providers who are medically billing health insurance company, you know, electronically billing health insurance companies for those services. And so HIPAA is not the right go-to. It's really a FERPA issue. And so it comes back to what's within their assigned duties. And if a teacher is assigned that duty, and then that's not a HIPAA, it's not a HIPAA issue at all. And in terms of it being a FERPA issue, if that's part of their assigned duties, it's not a FERPA issue. So I think just on that front piece to that's okay. In terms of, you know, the right way to go about doing it, you know, I've talked with many folks over the last couple of weeks about the right way to do it. None of them are perfect, right? If you have an electronic system, you know, there are people for whom that's not going to work. If you have a paper-based system, you're going to have people for whom that doesn't work, or that forget it, or other options. And so I think it's one of those things where we have to have flexibility. We need to make sure that we have probably multiple options for people to do that. And remember that that is a daily requirement, not a one-time requirement. And I recognize I've seen this question pop up here, so I want to say it, that the CDC has, you know, some have said have changed their stance on universal symptom screening. I don't care what the CDC says about that so long as IDPH and ISB continues to require it. And so to the extent your local health department is sharing that with you, they are not actively working in your best interests because they are not considering the state guidance. And I would ignore that at this point.
And I want to offer two additional pieces here that are important. First, the parent cannot certify at the beginning of the year or be told that it is automatic that if they send their child to school, that they are self-certifying. That it's not an automatic function. You need to have documentation of that, and that documentation should be kept regularly. I'd advise daily. Because the guidance specifically says it cannot be done once for the year. And I think what they mean there is once for a period of time. That is that when we send, we have to be certifying every day that that when we send, we have documentation that the certification is good for that day. I don't think that we need to take specific temperatures. We need to certify that they're below 100.4. I don't think that we need to take, I do think that we need to be more aggressive than simply temperatures. I've had a lot of districts that just wanted to take temperature and do that only on the way in. So they just have an infrared scanner and everybody on their way in. That's not enough. We also need to ask the symptom tree. Again, I agree completely that this is not a one size fits all situation. I've seen districts doing a lot of different things, and I think some version of all of them are good. So maybe some degree of self-certification from the parents that is sent with the child every day. That's going to work for a certain population. Then an iPad that has a form on it that can go to the parent, go with the bus drivers, so that if we happen to have a parent at the bus stop, that we can get that right before the kid gets on the bus. That might work for a certain population. Excuse me. Then additionally, redundant checks at the school, which is also going to work for a certain population. Now, remember, none of these is perfect because some parents aren't going to do what we asked them to do. Some kids are going to report things that aren't true. If you ask my daughter right now if she had a sore throat, she'd tell you, yes, she doesn't have COVID. I know because she was just tested. You're going to have to be reasonable and kind of move a little bit. I will also tell you that some of these kids have known conditions. Brandon, you and I talked last week about some of these situations where there is a known condition. And where you've got a known condition, I think that you are entitled to be some degree of reasonable, but it is important that we've got that medical documentation that can support that it is a known condition rather than just the parent saying, I know he's got a high temperature, let him go anyway. That's certainly not going to be good enough to be defensive of us. And remember, that toward immunity shield is the whole deal for us. We're trying to keep that intact. And that comes down to just not doing something that is willfully or deliberately indifferent to a known risk.
And I think sort of a follow-up question to this is sort of how specific that needs to be. So for example, the question is, if we're using the Remind app for that and parents just daily say good or okay, or, is that enough? And I think the answer, of course, to that depends upon making sure that on the front end, what does that mean? And so I think that there's going to have to be clear instructions so that when we get that confirmation from them daily, that there's been communication on the front end of that as to what that message means. And of course, who receives that message. So by putting that in that context where that's coming to the teacher, now you've put that responsibility on the teacher to be the one making sure that that happens each day. And that may be fine. I just think we need to make sure that we're actively thinking about, who gets that and then who is responsible for those next steps. And I think that's an important part to it.
And if we're changing the teacher's working conditions such that they're required now to keep those records or seek those records and check each of those records, we need to make sure that we've got an agreement with the union that specifies how the teacher is going to be recording that and how they'll be held accountable. I'm not suggesting to you that this is a situation where if they miss a kid, there's going to be a great big progressive disciplinary response. I don't mean for this to be scary. I do mean for us to be able to hold accountable teachers who say, yeah, generally we'll comply. And then we know what's going to happen here, right? There's going to be some teacher somewhere that says, I'm going to comply, and they mean to do so for the first couple of weeks. And then, the year gets kind of busy and they start to fall down on a couple of things. They don't check every name. And then we have a transmission event. And then you're going to go, oh gosh, I've got this problem with the community. How do I track this? And one thing that you need to be able to do from a liability standpoint is to be able to say, we've got a particular person who is in charge. That doesn't necessarily mean they're going to be liable for anything. It does mean that the school district, which is the entity we all serve and we all protect, to include that teacher, needs to have some forethought about what we're doing, and that we've got somebody who was legitimately being held accountable for this, even if we just have an accident, which is not willful deliberance, but failure to set a rule might be.
So the next question start to get into issues relating to wearing masks and those related things. I know we have some more coming back to some of these topics, so we'll keep working through and try and get through all of the questions. But the next question is, to describe the disciplinary process for employees who are refusing to wear a mask, both for certified and non-certified. My first thought to that is, if we have an employee who's pushing back on wearing masks, I question whether they should be in education. But I'll just leave that aside for now. But ultimately, I think the answer is, I'm not going to let them in the building if they're not wearing a mask. And then how would we handle somebody who is not at work? And think about that through progressive discipline.
And remember, you've got due process requirements. So they're going home doesn't necessarily mean immediately, that they're being terminated right on the spot. They lose all benefits. That's not how it works. They have due process rights, which means we're going to send them home, and then we're going to start and engage that progressive disciplinary response. That depends on a lot of factors, which include what protections exist in the collective bargaining agreement. How long has the person been there? Are we talking about a first day non-certified employee with no contract? I think progressive discipline there is going to move a lot faster than a 32-year tenured teacher who's nearing retirement. It's going to be a very different process. We have to look at all of those factors, but I think that generally speaking, what you need to know right out of the gate is, one, the person's going home. Two, they have due process requirements. So they're going home, they're not getting into the building, but we're going to start that progressive disciplinary process. And that's a place to take our time and make sure we've got it right.
Yeah, I think that's exactly right. And I think we're going to get into some conversation a little bit about, people who bring us doctor's notes, both on the student and employee side, and what that means and how we walk through that process. We've got lots of questions about that. Let's talk about that now. So let's start with the employee side. So let's say you have an employee who brings us a doctor's note that says they are medically unable to wear a mask. What do we do with that?
So again, I think some of this is going to have different results in different places, but I want to point out a couple of things. First, a chiropractor, there's nothing in the guidance anywhere that suggests to us that we lose the burden of being reasonable with what we've got. So just because somebody writes Dr. X does not necessarily make them a medical practitioner who has expertise in this field. So if a chiropractor says they're unable to tolerate a mask, period, end of discussion, that doesn't end the discussion for me. In fact, it barely even starts the discussion for me. There's nothing in that note and in the inherent in that doctor's note that tells me that they have expertise to make an appropriate determination as to what is the condition there. But remember that the Americans with Disabilities Act requires us to engage a conversation, an interactive communication about what accommodations are necessary for disabilities which are life impairing, major life function impairing. So one of the things I'm looking for is it covered by Americans with Disabilities Act? Do we have a major life function alteration issue at all? And if we do, and remember, we're not necessarily titled a specific diagnosis on that, but we are entitled to enough information to know the nature of the accommodation that might be necessary. If they can't provide us that, then we're also not required to accommodate on that basis. So if somebody shows up and says, I've got this doctor's note that says I don't have to wear a mask, I want to know what that doctor's note says. I want to know what is really happening, that what's the medical basis for this. I want to know what it is that you need as an accommodation, what I can do to help. But as a general rule, the purpose of the mask is not to protect the wearer of the mask. It's to protect all the people that the wearer infects. And so also remember that there is some explicit exemptions when there's a safety issue for the person that the person infects with ADA. And so therefore, I think in most cases, if you cannot tolerate a mask from an employment side, you're not coming to school. You're not going to be able to work in the building. And that comes back to the question of, do we have the ability to provide remote instruction work for the employee, or is this employee just going to have to be on leave for a period of time?
Yeah, I think that's exactly right. And I think the key there is it can't just be an automatic no. We have to first engage in the interactive communication process with the employee. But the likely outcome on the back end of that is either we have remote work available or we're not able to accommodate. So if they're going to be at school, they're going to have to wear a mask. Now, the other thing I want to think about when it comes to mask accommodations, and I would say this is going to apply both to our employee and our student conversation on this, but I don't think it's an all or nothing proposition. I mean, maybe somebody who has a medical condition that says they can only wear a mask for 30 minutes at a time. Okay, well then give them a break to go outside where they are permitted to take it off, and then return to work or return to class or whatever the case may be, and recognize that we can find ways to communicate with them. And I think that's where you start that conversation. Okay, what's the maximum amount of time you can wear the mask? And then we start to see whether there are ways that we can accommodate that, like having them go outside and distance for a period of time before they have to put it back on. And I think those are the kinds of factors that we want to think about in terms of how that plays out. So I think that's an important process. Next question here deals with employees who want to take leave to stay home with their own children because schools are remote or a hybrid schedule, and the right to do that. Is that an FMLA, and do we require them to pay for their health insurance benefits out of pocket? Well, I'll start. That is under the emergency FMLA and the emergency paid sick leave. So for up to 12 weeks, that is in fact an FMLA leave, and that is an FMLA leave at 2/3 of their pay in those situations. So it's a paid FMLA unless they want to substitute their own other available leave for full pay instead of the 2/3 pay. Because it is an FMLA qualifying leave on the health insurance piece, the employer, the school district, would have to still pay its contribution to health insurance benefits the same as they would as if they were employed.
Yeah, during that period. Now, I think it's also noteworthy that we're talking then there about deduction of leave. This is not just a freebie, you get to stay home until whenever you want to stay home. To the extent they have leave available, they can exercise that leave in order to provide for the child care under the EFMLA. But you should also understand that when that runs out, and it may, that employee is thus without leave available, and we look to the rules at the tail end of FMLA with what we do with health insurance and what we do with holding a job. Now, I want to acknowledge that right now, functionally speaking, terminating an employee for terminating an employee for an inability to come to work right now may be somewhat difficult and tenuous. So I want you to be careful as you walk through that process. I also want to acknowledge the other end of this, which is that if every employee takes the position, well, every neighboring school is all in remote learning, which could happen, and in some counties is already starting to happen. Therefore, all my employees who are all in these outlying counties are all staying home. I can't functionally provide work. I don't want to get into a situation where I've functionally made it easy for employees to have a conversation with me about this 5 minutes before school begins. So generally speaking, my answer on this has favored, at this time, it's going to shift a little bit in August and September. And so I want to acknowledge You're going to hear a place, at least with me, you're going to hear me shift on this a little bit. Right now, my position from a bargaining standpoint is we really need employees here. If there are things that come up that require you to be home, we acknowledge what your rights are. I'm not saying you don't have rights. I am saying I think you're permitted at this point through bargaining to begin that process of employees need to be here to perform that work. But that's a good place to have that conversation about what's going on in all these outlying counties and all these outlying cities, because if you find out that your employees are not going to be able to be at your work site, that may make the decision for you, because there is going to be an impact issue there. And remember, EFMLA is going to provide them up to 2/3 pay for 80 hours and then the ability to continue to exhaust their leave thereafter that they've already accumulated.
Yeah, and I think a couple quick follow-ups here on that. For the emergency FMLA, it is 2/3 of their pay up to $200 a day. And so I think that is, so we say 2/3 pay, but recognize that that's shortcut for the up to the maximum that's permitted. In terms of the emergency FMLA running concurrently with their accumulated leave, what the rule provides, which is different than normal FMLA, is that it's the employee's decision whether or not to run other leave concurrently. It does not necessarily run concurrently because they're entitled to that 2/3 pay. It would only run concurrently to the extent the employee wants full pay and therefore elects to run their other available leave concurrently in order to get full pay for those 2/3 pay situations under the emergency FMLA. I've also a question here about whether or not they still earn TRS service credit on that period of time. And I've gotten that question several times. I have not seen anything specific from TRS on this yet, David, unless you have. But under the existing rules, if that's a medical leave, a medical reason for leave, then that would be, certainly if it's FMLA qualifying, it would still be TRS service credit. And if it's otherwise a medical leave, I think that would qualify under the current rules for TRS service credit as well.
Yeah, and I think that, and those rules were just modified last year or the year before to broaden what constitutes certain types of administrative leaves for up to a year. I think it's very likely that we're going to see, it's not certain just yet because we haven't seen any modification of the rules, but to the extent that it's medically qualifying, to the extent that it's administrative for the purposes of providing or protecting the person's job while they're on that leave, I think very likely you're going to see that TRS service credit does continue to accumulate.
All right, David, I'm going to throw you an easy one.
I like easy ones.
Can we waive teacher evaluations?
No.
No. I don't know where
legal matter. The answer is no.
No.
Absolutely not. And it's not ambiguous. This is without any question. There is no question. There is no legal exemption that allows teachers evaluations to be waived. And I want to point out just a couple of things that I think are really important here. First, this bill, the discussion around this initially did come up with the unions, and you notice there was no bill that waived teacher evaluation. I've seen several drafts of various MOUs that suggest that the law that was passed last year somehow waived teacher evaluations and negated teacher evaluations and eliminated teacher evaluations. And that is a total mischaracterization of that law, in my humble opinion. As I read that law, and as I know those discussions were occurring at the time, unions balked at the idea of, we'll just waive evaluations and you can do whatever you want to do. But I acknowledge locally they're supporting the idea that we might waive them. And that, to my mind, is a trap. And the reason it is, to my mind, a trap is because if they don't want the waiver of your duty to perform evaluation, remember, it's not a right. You can waive your rights, but you can't waive your duties. If they don't want a waiver of the duties, but they're saying, we'll let you off the hook this year, I think what they're also saying is, we also expect that you're not going to RIF or dismiss anyone. And that's fine so long as there are no cuts to funding, and as long as I like everybody, and of course, as long as nobody has ever made any mistakes at all in my midst. But I know that some of the very best people in our field do dumb things. I know that some of the best meaning young teachers who look great in interviews sometimes don't perform the way we expect them to once we get here. And I know that life circumstances change. And I also know that yesterday the governor warned of deep cuts to funding for the coming school year, next year, not this year. But the state board's been making changes to the budget for this year in the way disbursements are going to be handled. That would scare me to death, to lose control over being able to conduct a reduction in force as necessary, for that matter, to be able to get rid of teachers. And I think a lot of this is predicated upon the idea that a teacher in their first or second year or third year or fourth year can be dismissed without cause. And that is false, and it's been false for as long as I know. Teachers can be dismissed without display of cause in a resolution, but that does not mean they can be dismissed without cause. It means that you have to have cause. And I'm telling you, I've been to federal court with first year non-tenured teachers challenging the cause because the teacher said the cause is for some illicit purpose, such as because I'm a member of a protected class or because I filed a particular complaint. You have to have evidence that that is not the reason, and your word is not good enough before a judge, particularly when the other guy's word says something else and it's he said. That's not a good case fact pattern. Here's what I'm going to tell you, and here's what I want you to believe. One, I could at least conceivably understand the idea that we want to sort of soften our reality with regard to how we're conducting those evaluations. We've got a couple of mechanisms to do that. One, you can direct your administrators to be rational, take it easy. In fact, I teach at ISU, and that's exactly what I was told at ISU, that they were going to be rational with us because they understand that student learning, even at the collegiate level, may not look like it did last year. They want to see that we're really trying to get that done. But they'll recognize that if we're not seeing assessment results that look the same, maybe we need to change the nature of our assessments. So one, you can do that. You can change your assessment data, figure out a metric that you can actually test remotely instead of using that metric that requires testing in-house, in person. So that's the first thing you can do. The second thing you can do is you can tell people we're going to chill a little bit. We're going to take it easy. And I want my evaluators to be rational. That way we're moving forward. We're keeping our stuff intact. And one thing I want to point out to everyone that I want you to be really careful of, there are bad MOUs floating out there that do not waive status quo, that say, this is the way we're going to do it forever. That is a very scary proposition to me, because I remember back at the beginning of SB 7 when we were researching districts that hadn't done evaluations, and somebody said, my district hasn't done it in 26 years. How did that happen? Well, this is how it happens, because a well-meaning MOU says we won't do it right now, and then somebody didn't check the Vienna case, which says that whatever we've been doing, we keep doing. Then you go back to try to do evaluations next year, and the union says, whoa, 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 you can't change the rules. We've got to bargain that. We're going to hold you up on status quo. And the administrator says, I'm not taking this fight on right now. I'm not getting rid of anybody. Then a new administrator comes back 5 years later, and he tries to, what? We're not doing evaluations. I'm doing evaluations. Then he sees the size of the fight and goes, now, wait a minute. Now, 26 years later, we're talking about a law that's upending everything that you guys have been doing for 26 years because you've been doing it illegally. My advice to you right now is be really careful with this stuff. Remember that until there's a change to the law, evaluation is a duty, and we need to protect our right to be able to do that and continue to do our duty to hold people accountable and train them.
Absolutely. And I am really nervous about the fact that a lot of people are sharing legal documents that are poorly written, that are not legally supported, and everybody thinks, well, so-and-so did it, so that must mean it was okay. And I caution you about that very carefully. And I think the other thing is, now, like if we need to take it back to the legal minimum, I mean, we can do that as long as we're hitting the legal minimums. I think that's okay. I think for non-certified staff, there are different implications of that. In terms of, because the school code is silent on that regard. But the bottom line is the bill this fall only fixed those evaluations that were unable to be completed last year. They don't necessarily have any difference for next year. And if
and
it
they
is,
could, depending on They could, depending on the way the order is structured. It's possible that'll fix the problem. But I'll be honest with you, the conversation I had with a lot of people was, what do you mean? We're in mid-March. You mean that there are districts that don't have evaluations completed here in mid-March, and they're trying to start from scratch on an evaluation? I, I want us to think that same way as we begin the year this year. You mean we've got an entire year to do evaluations? We're not going to do anything? And the other thing that scares me about that, remember, some of these MOUs were probably created, and Brandon and I know we both had this experience, recreate something that maybe it's not legal, maybe it's not really a good idea, but we create it for a narrow client issue. There's a political reality. We've got to create it for that person. And so we try to do the best we can for that school district, knowing, I hope this doesn't get out to anybody else, because I got a cover letter that goes with this thing that says, don't do this. Be alert to the fact that when somebody's sharing something with you, it may be for a very narrow issue, and it may not necessarily be legal, because they may not be warranting to you, they may not have the license to do so, that it is in fact legal and that it's supported and that they'll be able to defend you. And the secondary problem off that is, remember that you may have a community problem with some of this. I had one school district where the board got a hold of it and said, wait a minute, we're not going to hold anybody accountable for anything. So what if we just have teachers that just don't feel like showing up on time? What if we have teachers who are sitting at home in remote instruction, like Brandon and I are doing right now, and they just say, you know what? I don't care. I'm just going to put my hand up in front of the camera and not do any of the things that we've agreed to do. How are you going to hold them accountable? And the answer is, you may not be able to hold them accountable. And so you need to be careful that you're also spinning that public political narrative a little bit, that yes, we are holding ourselves accountable, even if we've sort of softened what holding us accountable really means. Sorry, soapbox. I'll get down.
Well, I know. And again, I want to appreciate that evaluations are a lot of work. And so I understand why, if any time anybody has a chance to get out from under that, I understand why they're trying to do that. But the legislature just doesn't let us do that.
Yes, absolutely.
So I'm going to now take a stab at another sort of easy one. Some sarcasm there. So does a doctor's note mean we must allow a student to attend mask-free? And I think the clear answer to that is not necessarily, and ultimately probably not. I mean, here's the view on that. The request to not wear a mask, particularly when it comes via the doctor's note, is a request for a medical accommodation. And what we have to remember are all the things we've always learned before. And so we know under case law and OCR guidance that when we get a request for a medical accommodation, that puts us squarely and affirmatively in no place other than either 504 land or IEP land for a student who has an IEP. So the easy part first, for a student who has an IEP, that's a request for an accommodation that only the IEP team can decide. And then the IEP team needs to make an individualized decision whether or not that's an accommodation that can be granted, recognizing, just as we talked about previously for adults, that puts the other people at a risk of safety. And we also have to recognize that it's not a one-size-fits-all yes or no. It's a what's the max amount of time that a student can wear a face covering, and during other times, how can we accommodate that? Can we provide instruction outdoors and distance, for example? Can we have others wear an N95 mask at times during limited periods of time? Those are the kinds of factors we have to think about. But I think that the answer ultimately has to come back to health and safety first. And that always has to be first. We don't want to unnecessarily put other people at risk. And that's what remote learning is there for those students who are unable to do so. Then remote learning is an option. I think for those students who are not an IEP student, that's a request saying, again, that has to be a disability is the only basis that we would be obligated to meet that, would be if there is in fact an underlying disability, which would mean 504. So we could only make that decision through a 504 process where we determine that the student does have a disability under 504, and then that would be an accommodation for the student on their 504 plan. Again, and I think the likely answer to that is, but that creates a health and safety risk for others that we are unable to grant. So I think there's going to be a very limited, if ever, situation where we're able to say yes to a student not wearing a mask while in a school building. I think we can find other accommodations like going outside and distancing for periods of time and things like that. But beyond that, I think that's a hard sell in terms of ever having a situation where a student is not required to wear a mask. And that's why, that health and safety exemption to the ADA and 504 exists. That's why, for example, Walmart can say, you can't come in unless you're wearing a mask. And we're giving you an accommodation that says, if you are medically able to wear a mask, you can order online and come pick it up. And we're doing basically the same thing. If you are medically unable to wear a mask, then you can receive your instruction through remote instruction. I think the next place that question then goes is, but some of those students who are truly medically unable to wear a mask are the same students who are least likely to benefit from remote instruction. And that's where I think FAPE and health and safety start to have a conflict with one another. And as those of you who know, in my special ed brain, as I've trained you, it's hard to get out of that idea of FAPE trumps everything else. I think it trumps everything else except health and safety. And if we really, we have to make an individualized determination. And I think that's what I have to emphasize more than anything, is it can't be a one size fits all determination. We have to consider all of these on a case by case basis. But I think we have to be very cautious about any student, regardless of their level of medical fragility, not being able to wear a mask. In fact, those are the students who probably don't have any real business being at school in the first place right now, given their underlying health issues and the possibility of exposure to others. So I think we have to be particularly cautious in that regard and make sure that we are making those case-by-case decisions when it comes to students. Okay. So let's go through a few more of these, and then maybe we can start hitting these a little more rapid fire as we, as
Yep.
we're getting through.
As always, we're moving slow through the big ones, and that is rush through as many as we can.
So we've talked about doctor's notes and employees. Is forcing a non-certified employee to wear a mask a legal condition of employment, and can they be terminated for insubordination for not wearing a mask? I think the answer there is subject to due process
Yes.
and progressive discipline, potentially.
Yeah, and again, I do want to be careful that as we go through that we take that slowly. I've had a lot of disciplinary situations where you get near the end of that process and all of a sudden a medical condition comes flying out of the sky that wasn't accommodated, and that kind of slows us up a little bit. So I want us, this is a situation where the likelihood of that is reasonably high. I will tell you that as masks started to become required in late June, early July, there was a lot of fear that there was going to be this huge influx of doctor's notes. And Brandon, I don't know about your experience, but mine has been, I have not seen nearly as many as I thought I'd see.
Very few.
And the reason for that may be that the American Medical Association gave notice to a bunch of doctors. I don't know that if it was broadly disclosed or only to particular doctors, that they may not have insurance themselves and they may have liability themselves if their notes are not medically supported. So I do think that there is some help coming from bigger organizations as well as from the state to try to help mandate some of these things. And it is noteworthy that there are a lot of court cases going all over the state, and the Illinois Supreme Court might take on a couple of these cases. In fact, I think has agreed to take on a couple of these cases in order to try to get at least some clarity for school districts, because I recognize you guys are kind of getting it from all sides. That you do the right thing on one kid and the other kid's upset. You do the right thing on this kid and that kid's upset. I recognize it's a lot of conflict there for you guys. And so it'll be good when we've got some consistent ruling on who's got authority for what. But the good news for right now is I don't think that we're going to see, nearly as many of these conflicts as we thought at the beginning we might see. And so when we have people showing up and saying, I'm not going to wear the mask, yes, I think we do have a disciplinary right there. And yes, I do think it's a condition of employment that's going to be terminable at the end. Yes, there's also a collective bargaining impact there. I did see one union that filed a demand to bargain on the requirement to wear a mask, but that is the easiest bargain I've ever done in my life. The position is the rule has changed. Just like, remember when we were talking about minimum wage thresholds and we said, you have to do it. It's also a mandatory subject to bargaining, but you have to do it. So you can't waive it in bargaining, so you have to do it, but it's a mandatory subject to bargaining. Same deal here. You have to do it. So my position in bargaining is you're going to do it. And if their position is, well, we want to make it optional, my answer is that you have to do it. And they say, but I want to make it optional. I say, you have to do it. And we've come to impasse like that. We just have to be willing to sit down and meet. And by the way, a failure to do so is ULP. And a ULP, an unfair labor practice, is a very expensive lawsuit that's a waste of time. And it's really easy to defeat. Just sit down and talk to them, even if it's by camera, by Zoom, for 15 minutes.
And, I think the other piece to it is if you've got, particularly with a teacher who is for non-medical reasons refusing to wear a mask, I would imagine at some point we could see some license revocation action starting for somebody not following the code of educator ethics by knowingly putting students at risk by not wanting to themselves comply with very basic requirements about health and safety.
I agree.
David, what would you recommend for a sick leave policy for teachers who may be exposed and quarantined?
So this has been a really tough thing to deal with right now in the midst of COVID, because I recognize there is a legitimate concern for health and safety of our staff. And there's a legitimate concern that if we're on school grounds, there is a possibility that there could be multiple exposures, which would require multiple leaves. Here's what I'm advising. I'm advising you to stick to the law. I recognize that sounds cold and heartless. I recognize that sounds like an awful thing to say. You're going to have to deplete your sick leave bank. You're going to have to do your accumulated sick leave over something that you were mandated to do by your employer. I recognize it sounds heartless, but it's the right answer right now. Here's why it's the right answer right now. Because if I'm granting large blocks of sick leave that are very difficult at this time to track, I mean, how are we going to get in to see doctors to certify that they had close contact? And the reality is, remember, it's not just a required quarantine because you have symptoms. It could be a required quarantine because you had close contact with somebody who had symptoms. That puts us in a pretty tricky situation in order to enforce these. If we create an unlimited block of sick leave, we are potentially subjecting ourselves to a lot of people out. And I want to be clear as well that this is not a one of these things where Brandon and I sit on here and go, this could happen, and you go, not in 100 years in my district. This is actively being talked about right now by both major unions in Illinois, IFT and IEA, who are saying we're talking about health and safety strikes. And when I hear that, I'm hearing something that sounds a little bit like a sick out. And a sick out would be where you have a lot of employees who call in sick and use up that sick time. And if I've created for myself a policy that creates more than the law requires, creates more sick leave, then potentially I'm paying for employees to stay at home, which is forcing me into a remote environment that may not be what my plan says. I mean, whether I should be in remote or not, that really ought to be fundamentally a board decision subject to collective bargaining, not an individual employee decision, which is forced upon the board, where they're then having to communicate to the public that it was done to them because of a squirrely agreement. My advice is your MOU, first of all, you need to have an MOU with your union. Second, that MOU should say leave is as by law, or it should be silent so that leave automatically is by law. If you're going to say anything on leave at all, it ought to be stuck to the law, because if you start granting additional leaves on top, you may be paying for a lot of people who are out at one time and forcing yourself into a remote learning environment exclusively.
If the governor issues an executive order for all schools to go remote learning, can I legally require employees to come in and teach remotely from the school if the order doesn't include a shelter-in-place order?
Brendan, I used to have an 8-ball up here. I don't see it. I mean, that's part of the problem, right? Is we don't know what the governor's order is going to say until it comes down, and we only know it 30 days at a time. So it's a little bit of magic 8-ball. Maybe under previous orders, yes, schools were essential service, which allowed us to open and command people to work if we could get agreement from the unions. Initially, that was an impossible task. I had districts that tried it, had agreement on Friday, and by Saturday morning, said agreement wouldn't be signed and was getting blown up. On the other end of that, about 2 weeks later, after the governor had switched all the orders and extended the break and had created this remote learning day that had never existed before, we started to see a little bit more leniency in some places on some conditions with some hours, but not total hours and those kinds of things. The same thing's likely going to happen again. If he shuts everything down, even in a region, some of that's going to be dependent probably on what the local health department is saying in the region, because if there are catastrophic rises in numbers, remember, this happened already in the United States. Didn't happen in Illinois, but in Arizona, they were mandated to come to work to provide remote instruction, and 3 teachers were in the same classroom providing remote instruction. All 3 of them came down with COVID, and 1 of them died, because the union alleges they were required to be within the school building. So be alert to the fact that some of this is going to be as we move. And so one of the ways I've tried to accommodate that in MOUs I've drafted is to say, if the governor allows, if the order allows, then we will have the building open in order to permit work on site, and then whatever the rules the district wants to be able to provide their remote instruction in a way that's feasible.
So, David, if an employee has chronic migraine headaches, provides a doctor's note with that diagnosis, can they attend work even though they would have to check yes to the headache box on the daily health check sheet?
I think this comes back to our discussion a little while earlier on EFMLA and being rational with people. I'm sorry, self-certification and being rational with people. I think, one, if somebody checks the boxes, yes, we're required to exclude. However, if we have written evidence, written medical documentation of a known condition, I don't think that we can exclude, or that we necessarily ought to exclude people because of a variety of conditions that are known issues that aren't necessarily symptomatic of COVID. Again, I think that's case by case, but I am looking for medical documentation and some reasonable assurance and certainty for the school district for liability purposes that we are not looking at a COVID case, but rather a chronic known condition that we do have that we can document, that we can assure that to some reasonable degree of certainty that it's this and not COVID.
So a couple student questions here. Number one, we have a student who is eligible for a 504 plan and his parent has elected the remote learning option. Do we need to have the 504 plan now or wait until in person? And the answer is we need to do it now. All of our child find duty requirements are still in place. And we would also always have to consider any 504 accommodations that would be necessary during remote learning as well. And so I think we need to do that now and consider accommodations both for remote learning and for in-person learning. Several questions sort of around this theme. So I'll talk about this. We've discussed remote learning plans that were in the spring are unlikely to be sufficient for this year. And I'll say the reason for that typically is because in the spring, it was pretty much anything goes. And now we've got the 5 clock hour requirement, among other things. Do we need to have IEP meetings for students who choose remote learning, or can we do an amendment to change the remote learning plan? And I think the answer is to that, yes, to either of those are your 2 options, right? If you are modifying that, your 2 IDEA sanctioned ways to do that is either to have an IEP meeting or an IEP amendment form, which, remember, that doesn't necessarily mean amending or changing the actual IEP. That's a form we use to show the parents agreed to a minor change in the IEP. I think that is a sufficient way to do that. Relatedly, I have several questions here that are special ed specific, so I'm going to go through those, and then we'll start going through the chat box a little bit more. So I'm going to try and answer these. Can we give an example of an appropriate plan for mask training and when a student with an IEP can be excluded? And I do think that that's something we want to think about, right? One of the things I've been emphasizing is I don't want to make assumptions that students are unable to wear a mask or face covering, especially when we think it's behavioral or sensory. I'm going to try and make it work. And then we're going to try and make sure that through that process, we are, maximizing that. And if it's not working, then I think we have to look at exclusion or other accommodations or remote learning pretty quickly. But I don't want to assume that a student's not going to be able to wear a mask. I'm seeing that right now with daycare and toddlers. They're doing it, and they're doing a great job of it. And everybody at the beginning said there's no way this is going to work, and they're doing it. So I think we don't want to sell kids short in terms of thinking about it. Is it okay during this time to change occupational therapy and physical therapy goals so there is no touching of a student? Many goals are written to allow for physical or hand-over-hand assistance, but staff is nervous about this. I think ultimately we can still, with appropriate PPE, meet those goals. I think the issue for me sometimes, I think based on the ISB guidance, IEP goals should, for the most part, remain unchanged and be fully implemented, but how we're measuring progress might be what we have to change or consider differently. So I think we want to make sure that we are limiting that physical contact and we are maximizing social distancing, but recognize that right now in the medical field, people are successfully providing that in a safe manner. And so we need to look to what's happening in the medical field for our examples of how to implement those goals. If a parent chooses remote instruction, do we have to allow that student to come into the school for related services, or can we insist on those remotely? And I think the answer is that ultimately is going to be an IEP team decision. I don't think we can insist on anything. And here's the reason why I say that. We now have the first COVID-related federal special ed decision last week out of New York, in which the court said there was a denial of FAPE by not offering in-person services on an individual basis, even though everyone was required by order of the governor to be remote. I hate the decision. I would be hopeful that there's an appeal and it would be different on appeal, but what it emphasized to me is individual decision-making must always be the answer. If our answer was we didn't allow it for anybody and that's why we didn't allow it for you, that is not meeting the individualization requirement of the IDEA. I'm not saying that we ultimately must allow that. I think it may end up being that it is still that those are going to be remote, but it's not because we insist or because that's what everyone else is doing. Because remember, an IEP is an individualized education program based on what this student needs, not what we're doing for other students. And so we always have to at least consider whether or not that can feasibly happen in person. And I think that's the important point to it. We can't just make an insistence about this. In terms of individual remote learning plans, again, I think we have to improve upon what we did in the spring, because what we did in the spring, we all were flying by the seat of our pants, created them quickly, and there were no rules in terms of what we had to do. Now there are expectations. Remember, it has to be FAPE, it has to be appropriate progress on all IEP goals. And so I think the actual form itself doesn't change, but what goes into the form we have to make sure is meeting all IEP goals. It is FAPE, it is appropriate progress. So I think that is important to do that. In the event we go fully remote, should we have parents sign a confidentiality agreement about observations in the classroom for online sessions? I think we have to make sure that they're given notice of confidentiality requirements, but I don't know that we can require them to sign any sort of waiver of those rights in order to do that. In fact, I don't think it's legal to have parents waive their rights to FAPE or their rights to FERPA or anything like that in order to participate online. So I think we have to have them acknowledge maybe the limits of that, but I don't think we can ask them to. I don't think there's an agreement in that regard. And in terms of if the parent's observing, I mean, Department of Ed has said parents always have the right to observe, and that doesn't create a FERPA or privacy issue when parents are observing. So I think that is an important piece to that. All right. Just one more set of questions here on special ed, and then let's start going through. There's several other great follow-ups in the chat box I want to go through. But here, question here, mom has requested an IEP meeting because the district has elected to begin in remote learning. Mom wants to dispute the remote learning plan, and she wants full IEP minutes during remote learning. She wants the one-on-one assigned to do that. She wants, the daycare is difficult, and she wants her child not to wear a mask when she's on campus for in-person learning. I mean, first of all, my answer is she may want a lot of that. Very little of that may actually happen. But I think to the questions here on that, how much can we reduce direct time on a remote learning plan for a student like this who's in a self-contained instructional program? Well, I think we always have to start with their regular in-person IEP and then see where we would modify from there, recognizing the 5 clock hour requirement. So I think that in the spring, I think we had a lot more flexibility to be able to reduce that time because there wasn't a specific 5 clock hour requirement, and some of the time recommendations for students were pretty minimal. I think now we have to make sure it's FAPE, and so I would be cautious about reducing the amount of time very much because we want to make sure we're still making appropriate progress on each IEP goal and are basically implementing the IEP, although there may be some minor reductions in the day given the remote or hybrid situation. But I would be very nervous about making much differentiation from that during this period. In terms of providing one-to-one paraprofessional support, in terms of that time during remote learning, I think we have an obligation to consider how that would be implemented or whether that's not necessary given what their role is. For example, if the purpose of that one-to-one support is toileting and medical and all those things that are only really going to happen because of the in-person nature of school, then maybe that one-to-one support isn't necessary, or certainly not to the same extent. But I think what we have to do is, depending on how that remote learning and what the role of the teacher is in that remote learning environment for that student, I think that would then dictate what would be reasonable. How can that, paraprofessional be supporting that student remotely in different ways, given the instruction. So I think that might be a situation where the level of support from that paraprofessional is very different during remote learning, but may not go away entirely. And I think we've covered those conversations about without a mask, it's going to have to be outside and distanced. I think that's the bottom line in that regard.
And Brandon, how does that apply when if the district is put in remote only instruction and the parent is insistent that some of this stuff needs to be done in person?
Well, I mean, I think that ultimately, if we are not permitted to do in-person instruction, then I think that gives us a pretty good safe harbor. But I think we have to be careful about not at least giving the parent the meaningful opportunity to engage the IEP team in that discussion. I think if that's a local decision to be remote learning, I think, again, we're unable to just say, sorry, we're remote, given the case law that exists. Mm-hmm. I think that it's going to have to be a non-local decision that it's remote in order for an answer like that to work. Otherwise, the IEP team is going to have to make sure that whatever is happening through remote, in-person, or some combination thereof is still FAPE, on all of a student's IEP goals. And I think that's particularly important for us to think about. All right. I'm going to start scrolling back through because I know there's several questions we missed through the chat box. So I think there are a few things here that I want to go back to and think about. I'll start with another special ed question here. Do we put start and end dates on remote learning plans or blended remote learning plans for students' IEPs? And I would say, no, we would just simply say, this is in place on a declared remote learning or blended remote learning day. And on any such day, that's the plan that's in place.
And I think that's really important in our collective bargaining agreements as well, is that we take into account the flip-flop in and out, that we acknowledge these are the rules when we're in instruction, these are the rules when we're remote instruction, these are the rules when we're in something that is a blend of those two if we're intending to do that, that we make sure we have adequate employee responsibilities set forth there for each of those situations.
A non-COVID question, any update on when press is coming out with the Title IX language? I know some of you might be on here listening to us who are responsible for that. So I'm not going to throw you under the bus other than I think it's coming soon. And if any of you all with inside knowledge of that want to, put the answer in the chat box, I'll be happy to share that with the group.
We will share it.
Do we need to have a supplemental COVID personnel handbook to address some of these scenarios? I think that there are certainly required notices we have to give employees, like their rights under the Families First Act, among other things. I don't know that that's so much as it is a supplemental handbook as it might be a fact sheet or memo that puts those things together for employees. I've helped people design and create some of those things that are going out. So I have a lot of districts that are using, their plans that they put together for reopening school and or their MOU with their union to serve as that then they are sharing with employees. But David, any thoughts on that?
Yeah, so one thing I've seen a whole bunch of that concerns me a little bit on exactly that end is this idea that we'll put together a policy book for COVID and then publish it to the staff. And I've already seen a whole bunch of demands to bargain on that very issue. I don't like that procedurally because I think it misapplies the role of the union in policy making, particularly where that policy making has a direct impact on their daily work. This is not a situation like when we're talking about a law changed on something that doesn't really affect the staff much. Say, for instance, student discipline doesn't affect the staff that much, and so we change the policy handbook. That, to me, is very different than a situation where we're talking about the rights of the employees and the work requirements of the employees. It would be a little bit more like when we're talking about changing the length of the school day. That's a really sensitive topic with employees. In fact, Chicago took a strike over that several years ago. If I were you, my advice to you is that conversation needs to start with the union, not end with the union. I don't want you to start by adopting a policy and then providing it to the union members and assuming they'll just follow it, because I've seen a whole bunch of situations where we've done that and the unions file a demand to bargain. And then we're at status quo and we can't implement it. And of course, now we're stuck with the stain of, we don't want to do that. I don't want you to do that. What I'd like you to do instead, and what I think would be really helpful, would be to start with the union with, do you agree to this? And then because all of you are doing such a great job of that right now with your plans, you're having great conversations, the union gets it, you've got good relationships, maximize that now with, okay, now let's put it in writing and we want you to sign off, this is what we're doing and that we agree to it. I've seen a lot of plans that are very thick on this is what the guidance says, but very thin on here's how it's actually going to throw out to the staff and how we're actually going to hold the staff accountable for these rules. So I want you to make that next leap while you're in the process of that really good discussion and just take that extra step of putting that stuff in writing. And I think that is going to do the best job you can do to both keep that relationship healthy, which is tremendously important and will save you a lot of money in fees with us, but also to do yourselves a favor of calling out any trouble before it comes so that you can hold them accountable for those policies that you're going to implement.
Next question here, is there a recommendation from either the CDC or IDPH for the number of cases where you should close a building or a district? Like a percentage of staff or students. My union is asking for one, and I don't find any guidance on that. I don't think there's a specific answer. When you look at the cleaning protocols, I think those are really, it's a matter of close contact. And then I think you're really going to have to make that decision in consultation with your local health department in terms of once you think that you've got a number of classrooms or situations where that happens. Right now, again, the closest analogy I can see and what I've seen happening this summer has been daycare for my kiddo. And she's been, they have had a classroom where that classroom had to quarantine for 14 days. But it was a different age classroom. They've been doing a good job of keeping groups separate, and not mixing teachers. And so everybody in that classroom did. And so far, that's been the only time where that's occurred. And I think that that's frankly lucky that so far that's the only time that that's occurred. But I can foresee that that's going to be something that will happen to you.
And I want to address, because I think I saw this question elsewhere in the chat. I don't see it right now, but I saw it elsewhere, and I think this is tangential and sort of dovetails nicely. It is the discussion of what do we do when we inevitably get that positive case. A couple of things that you need to be alert to. One, I don't want you guys to take on responsibility of the world that is beyond what you guys are really trained to do. I've seen a lot of plans that say, we'll start the contact tracing process. We will announce to parents this, but not this. I've sort of tweaked that language a little bit in the plans. And what I've tried to say is, we will assist the health department with their requirements to conduct contact tracing. We will share information that we know of who needs to quarantine as such information is shared with us. It's not your duty, and you shouldn't take that on to do all the contact tracing. It is your duty to do what you know to be reasonable. So if somebody reports to you, hey, I was in close contact with somebody who tested positive with COVID, okay, you're in the quarantine protocol. That may result, particularly for a district that has classrooms with 2-foot spacing, okay, that may result in an entire class ultimately being subject to quarantine. But there's no threshold beyond which everybody has to quarantine or when you're going to get shut down. That's not a decision that you guys ought to be making on your own. That's a decision to be making with your local Department of Public Health, with the Illinois State Department of Public Health, with ISB, with the governor. With council, there are a lot of people you're going to work with. Build yourself that team of trusted folks that you're going to work with when that inevitably happens. And then those folks are going to help you. You don't have to make that decision by yourself. And remember, being an island makes you an easy target. If you are in fact on the shore, on the continent, then you're going to be a lot safer.
Back to the Title IX question, my inside answer is the goal is for that to be out before the August 14th deadline. So we should be seeing that. Hopefully that'd be in about a week or so. So yep. Hopefully for that. Some questions here about what if we are recording in-person instruction and a student appears in that video inadvertently or probably they're likely to do so. Do we need parents to sign any sort of release if their student might show up in the video?
I think the answer is no, because the appearance itself doesn't create a student record. But I'll tell you, just for the crowd, I just saw very recently a plan that I really liked that sort of accounted for this reality that unexpected things happen within the classroom. They said, while we recognize that student existence may be directory information, teachers are encouraged to familiarize themselves, and the district will work to make teachers familiar with students who have those no pictures of my student form signed under FERPA. And on top of that, if a teacher has to manage a disciplinary situation within the classroom, they are encouraged to pause the recording where necessary. That's a double-edged sword, because on the one hand, I want them to be able to conduct discipline as they need to privately, but also I don't really want them to hit pause on the record so they can do things they're not supposed to do. And so we need to be careful how we implement that. But I like that the district was really thinking through those issues and talking through them with their union. And so just a couple of things for you to think about. I don't think that you need to be worried about incidental transmission of the identity of a student, but I do think that you need to be thinking about what happens day to day in the classroom that you need to address.
Can a district say that all IEP meetings must be held virtually? Well, I would say if we're talking about right now, I think no. I think that we still are encouraged to do them. The rules have always permitted virtual meetings, but that if a parent, wants to be there in person, I think that we would permit that to the extent we're still allowed to have in-person meetings and we're not in shelter in place. So I think we need to encourage those virtual meetings. I think we can have our staff be virtual to the extent necessary, but I think we have to look at that on a case-by-case basis. I would say I'm saying no to parent volunteers right now. We love parent volunteers. We want to encourage parent volunteers. I think right now is not a time to be having parent volunteers in and out of the classroom.
And remember that from a liability standpoint, they may not be treated the same way as an ordinary volunteer, because it's possible that they'll be given one of those higher levels, such as invitee, or maybe even, heaven forbid, an employee in some situations.
I'm purposely not answering any of the questions that have been asked related to the Chicago Cubs, noting that I don't think it's fair to compare records when you've played almost no games because half your team has COVID. That's just my life, right?
I blame the Cardinals for Iowa ball not happening.
Question here: any schools going against the grain and not participating in fall sports? Some have been practicing the risk increases, and that jeopardizes the start of school. I've had some talk about it. I think that politically, I don't know anybody who has said, even though we can have some fall sports, that we're not going to do it. David, have you had anybody just say no to fall sports at this point?
I don't know that I've had anyone make the determination. Absolutely not. I've had 2 districts I know of that are holding to see what happens, but have not immediately made the declaration. I am aware that there are a lot of districts that are carefully balancing that, knowing that it may jeopardize in-person instruction. And I particularly point out in the central area of the state and the counties that have seen some spikes, I know there have been some really intensive discussions about the fact that that may jeopardize the thing that we all care about the most, and that is getting kids back. And so we do need to think about that pretty carefully. And remember that football at this point is pushed off to next semester. And so that may, at least for the moment, and so that may take some of that pressure politically off shutting down sports right now, because football does, for better or worse, tend to drive a lot of those decisions.
I recognize, yes, we do have hockey right now, so maybe I'm going to have to jump back on my Blues bandwagon. If a parent chooses remote learning, do we ever have to provide services in the home? I think the answer is no. Even with homebound instruction, the regulations say that can all be done telephonically or virtually. So I think recognizing that's already in the existing homebound regulations, I'm not going to go into the home in that regard. We've talked about the sick leave piece. For in person, should teachers give assignments, collect the work, provide library books, or should everything be submitted online? I mean, I think we need to recognize that we want to limit the physical contact. And so to the extent that's an option for us, Otherwise, I think if we're taking appropriate hand washing and other sanitizing precautions, handing in assignments shouldn't be an impossibility.
Yep.
So David, there are several questions here in the chat related to the topic of providing daycare for employees' children. And I know that's coming up in several places because, maybe districts are having a shortened day or an AB hybrid schedule. That puts a burden on their teachers or other employees if their kids are not going to be in school on those days. So I guess and I know some districts that have gone down that path and created some agreements with their unions on that purpose. So any thoughts on providing that daycare for children of employees?
Yeah, so a couple of things. First, remember that we don't know what the next order looks like, and so with each order we get, the rules may change. So by the time we're at the end of August, the governor may be issuing an order, particularly regionally, that prohibits that. So be alert to the fact that could change. One, two. I want to acknowledge that there is a big problem for our teachers when we're saying you have to be here to do the job and your kids have to be home. That's not going to work very well for everybody. So I acknowledge there's a good reason to have that collective bargaining discussion about that and to work out solutions where you can that work best for the district. But that's one very compelling reason that some districts may be in a situation where they say, we want to mitigate that risk, because you should also be aware that when you're inviting people onto your school grounds and compelling them to be there, fundamentally, you're going to assume a little bit more liability. So one of the things that I've seen a lot of districts doing is, okay, so we'll have one teacher, one aide or whatever, who's responsible for monitoring 20, 30 kids who are all children of these staff members. And I'd caution you that there is no waiver of liability that's going to be very effective in that situation. I had one district that said, well, what if they just, in exchange for doing that, they waive all liability? I don't know that you can waive willful and wanton or deliberate indifference to a known risk. So I'd caution you that if you're coming up with a plan like that, that you think very carefully about how many kids we're really talking about, where they're going to be, who's going to be responsible for monitoring those children, and who's going to be, and how they're going to implement that monitoring, and how you're going to hold them accountable to assure that children remain safe, not just when they're within the building, but also when they're bringing things into the building and bringing things home with them.
All right, David, I'm going to force us into lightning round mode here. So
okay,
this is a struggle for us, I know, but we're going to do it.
It is.
Are we on sound legal grounds to begin asking employees to do symptom checks now, knowing that we're now getting on the cusp where we would be starting school? So we know who might be out the first day of school.
Yes.
I think so too.
Subject to collective bargaining requirements.
That's right. Make sure the union's on board with that. Yep. Let's see here.
I see one here on 72 and 24-hour regulation, because that changed in the phase 4 guidance, that it went from 72 hours symptom-free to 24 hours symptom-free. Brandon, which is it right now, 72 or 24 hours?
24. They've changed it back.
They've changed it. It's 24 now. It used to be 72 hours. That doesn't necessarily mean 72-hour exclusion is going to be bad in certain cases, because that may also overlap with 10 days from cessation of symptoms, from onset of symptoms, but be alert to the fact that they did change it. It's reduced now to 24 hours.
Great question here. Can all students self-certify no matter the age? No, they must be 18 or legally emancipated to self-certify. An employee can self-certify, or the parent can certify for the child, but the child under 18 can't certify for themselves. Let's see here. we had registration yesterday, and a parent refused to wear a mask and said we can't ask him why due to HIPAA. Well, I think the answer is
False.
we don't have to permit them in. It's not really HIPAA, it's the ADA for that
Right.
place of public accommodation. We would tell him, no, you're not allowed in, and your accommodation is you can register online. But we do not permit them in the building without a mask. So the options for teachers who say they cannot return in person due to their underlying health condition of themselves or their household, I think that's where we go back to the general leave conditions that are available. So we would go back to the same options in terms of the family's first leave, available other leave under the collective bargaining agreement, or potentially an unpaid leave of absence available under the collective bargaining agreement.
Yeah, and remember also to check your past practice on that, because a lot of school districts have had situations with new parents who've taken a year leave of absence. That strikes me for childcare reasons, that strikes me as a very analogous situation to what we're going through. And to be honest with you, I had a conversation with someone and who was very concerned about that. And I said, from a practical perspective, how many of your teachers can afford to take a 1 year unpaid leave to stay home? And the answer was, that's a good point, not very many. So be thinking about that a little bit as well, that if we grant this, yes, we may be opening up a Pandora's box, but that Pandora's box may be smaller than we think.
If a district goes full remote and only staff are present, for the purpose of recording lessons or Zoom meetings, can the teacher remove the mask to record the lesson, perhaps with the door closed, when they are sure they are socially distanced?
The answer right now is no, pursuant to the guidance. The guidance doesn't have an exemption in there for as long as you're socially distanced. If you're in school, you're required to wear a mask. I recognize that sounds insane. I fully understand it, but what the concern is the transmission of the aerosols, that if a person is in a space and has COVID and is asymptomatic with COVID and fills the space with their own germs, that could potentially transmit COVID within the room.
I think we've talked about this, but employees who have other illnesses are probably going to be excluded unless we get medical documentation that they are okay to come back. I think a question that pops up here is a negative test okay to allow an employee to come back? And the CDC has removed their testing, basis. I mean, Illinois, we had linked to the CDC guidance that previously had a testing if you had 2 negative tests 24 hours apart, and the CDC has taken that away. Now, I suspect that that's because there are members of the federal government that want fewer tests to be performed, and therefore that's a part of it. But recognize that testing strategy has been taken away under the current CDC guidance last week.
Which means that at this juncture, negative test is not a mechanism to get back in earlier. We had hypothesized, I think, on an earlier one of these, Brandon, that eventually that might be a remedy that is be added to get people back in faster. And in fact, with that gone, at least I don't think that is a remedy that's viable at all, unless ISB and IDPH come up with their own. And again, I'm looking to IDPH because they're the ones who have direct authority over us within this state.
How do we handle evaluations that special ed evaluations that need students to remove their masks for a portion of the evaluation? You do it outside and socially distanced with additional PPE. And I think that's the only way, or you do it virtually where you're watching the student on a video monitor. I think that's the only way to do that. If a teacher has a child have a positive test, so the whole class is on quarantine, can the teacher be required to work remotely with the students? I think the answer is presumably yes, but that's also a mandatory subject to bargaining.
Yep.
Our teachers are providing their union with their individual issues and want each of their individual issues to be part of the MOU. Any guidance on how to steer that?
So Uh, First of all, I'd acknowledge that sounds like a union that's got kind of a tough leadership situation, which is to say you're going to have to be the leader. Recognize that one, they get to bring any issue they want, but sometimes you're headed for a situation where they're bringing 186 issues. They don't have any leadership to call those down, and you are up against a deadline. That strikes me as a situation that's probably headed for some degree of impasse implementation. So be alert to and make sure your union is alert to what the deadlines are for various decisions. That doesn't mean you can't keep bargaining after the fact, but be careful that you're keeping good notes of every time you meet to bargain, good notes of what you discussed, and good notes with the decisions you made during those discussions, because that's what's going to protect you, that you really didn't make any progress because the union brought too many stinking issues. The way you steer that is, look, I respect that issue, but if it's not shared with the whole union, can we deal with that on that person? And if it's not a broad issue that everybody's suffering, can we find a resolution here? And if we can't find a resolution here, you need to be aware that we go back to school in 2 weeks, and in 2 weeks, this is what I intend to do unless you have a change.
That New York special ed case was JV2 versus New York City Department of Education. The judge's decision, I think, was July 18th, was the magistrate opinion, and then the federal judge adopted the magistrate's opinion last week.
Brendan, there's a good one here about when something is subject to bargaining, who do you include in that process? And that is totally up to you. And that's why it's a great question, because you have the right to make a determination as to who's going to be on your side, which means it could be the superintendent and the union president. But the union has that same right on their side. So it may be 40 members of the union, but that's their call. You don't have any control over that. You need enough people who have authority to make the decision, and not so many people that you slow the decision down. And I think that depends on the decision you're making.
So we're well past 3:30 now, David, and I think a lot of the questions are back to the same themes. And so I think I just want to, finish up by again thanking everybody for their hard work. We have recorded the session, so our intent is to post that. I've had several people ask whether we were recording, so we did record today. And so our hope is, as soon as we can get that up, we will post that to our YouTube channel. So, and if you want to watch the ones we've done previously, I had one that was just special ed, and the Q&A that David and I did in July is also there on our YouTube channel. So if you search for Miller Tracy on the YouTube channel, you will find that. But, there's so much going on, so many questions. And so, we are happy to be able to do this for you all. And, we know there's going to be a lot to do.
We'll keep doing it during this fall semester as long as we continue to be in this environment. We'll keep getting information out there as best we can. And please, to the extent you've got questions, please keep asking them, because they really do help.
So thanks for everything you all do, and hang in there. And I'm sure we'll talk to many of you soon. So thank you so much.
Thank you all.